Good afternoon, everyone. On behalf of FIBA and Baker McKenzie, I would like to welcome you to today's webinar on attorney-client privilege in regulatory examinations. Just a little housekeeping before we get started. If you have questions during the presentation, please type them into the question box in your GoToWebinar control panel. You may submit your questions at any time during the presentation, and we will address them as many of them as possible. I am Daniela Fonseca. I'm going to introduce the speakers. I'm Daniela Fonseca Pudina, and I'm a principal in Baker McKenzie's Miami office and co-chair of the firm's Global Financial Institutions Dispute Resolution and Compliance Steering Committee. My practice is focused on resolving disputes for financial institutions in securities and shareholder derivative litigation, criminal and regulatory enforcement matters, and corporate internal investigations. Terry Gilroy is a partner in Baker McKenzie's Compliance and Investigations Group and is based in New York. Prior to joining Baker McKenzie, Terry was the head of the Americas Financial Crime Legal Function at Barclays, based in New York. In that role, he advised business and compliance functions on issues relating to anti-money laundering, economic sanctions, and anti-bribery and corruption, and conducted related internal investigations. Jonathan Edward Adams heads Baker McKenzie's compliance team in Mexico and is the Global Compliance Practice Group's regional coordinator for Latin America. He's admitted in Mexico, Illinois, and Arizona in the United States. For the financial services industry, he has counseled clients on regulatory requirements in various jurisdictions in the Latin American region and conducted trainings on fiduciary duties in Mexico. He also advises domestic and multinational clients from various other industries on compliance issues in Mexico and other Latin American jurisdictions. His work focuses on internal investigations in government-related corruption cases and employee white-collar crime. Having worked 7 years in the U.S. and 14 years in Mexico and Central America, Jonathan combines a U.S.-based perspective on legal implementation and compliance issues with years of on-the-ground experience in Latin America. Jonathan will be here providing us with the Latin American perspective on our topic of today. And I'm not going to comment on the fact that counsel named Jonathan Edward Adams will be speaking on Latin American issues. Jerome Thomas is a partner in the Chicago office of Baker McKenzie. He is the chair of the firm's Financial Institutions Enforcement Group. Jerome is a former member of the SEC Division of Enforcement Cyber Force, the agency's Internet and Cyber Fraud Unit. Jerome regularly advises companies involved in data security breaches and incident responses. He's an expert in regulatory enforcement and white-collar issues with extensive experience representing clients in government litigation and enforcement investigations before the SEC, DOJ, various U.S. Attorney's Office, and the CFTC. He's super fun, notwithstanding his past. The agenda today will cover the attorney-client privilege, and we'll give you an overview. Then we'll discuss the DOJ and the SEC policy on privilege waiver, the federal bank regulators, protection against waiver, and we'll provide you with some practice tips for protecting privilege. And throughout the discussion, we will discuss how it works in the US and Latin America. I'm now turning on to the speakers with Terry Gilroy starting.
Great, thanks, Danny. So I thought to sort of kick things off, we would just do a quick overview of the attorney-client privilege and what it is. We'll just spend a couple of minutes because I'm sure folks that have dialed in are aware. But I mean, look, generally the attorney-client privilege protects communications made between attorneys and clients in confidence, where the purpose of the communication is securing or providing legal advice. And we spend a lot of time in investigations trying to protect the privileged nature of the work we do in connection with an investigation, the communications that we as external counsel or internal counsel have with our clients. the courts in the U.S. have as we talk about issues of waiver, it's important to understand that courts recognize that corporations operate in complex environments and therefore need legal advice from experts in the field. And I think we'll see, as a general matter, courts are loath to find waiver absent circumstances where waiver is clear. And one of the reasons why we're so concerned with protecting the privilege is really in the context of follow-on civil litigation. Oftentimes, what we will have is we'll do an investigation, we'll engage with authorities. Sometimes we'll reach a settlement or some other resolution of the issue, and then several years later, or months, or sometimes just weeks, we'll have to deal with follow-on civil litigation, and it's protecting the communications and the documents that were either prepared or created in connection with the investigation that we're really concerned with when we deal with these issues of waiver. So just for a couple minutes, maybe Jonathan will talk just a bit about the privilege and its application in sort of Latin America generally.
Thanks, Terry. Yes, it's very important to understand the difference between the protections that the law provides in the United States and the protections that it provides generally in Latin America. I can talk to the law specifically in Mexico. I'm admitted here. I grew up in Colombia, South America, but I'm not admitted there. So, but the laws tend to be very similar throughout the region. They're based really on the concept of attorney-client confidentiality. So it's really the duty of the attorney to maintain the documents and information of the client in confidence and not reveal those to third parties. And it's the right of the client to have the attorney abide by the client's wishes in that regard. But it's really not something that prevents authorities or theoretically third parties from obtaining those documents. However, it's really important to understand that really one of the reasons that this has not been a significant issue in Mexico and other Latam jurisdictions is that discovery is really quite limited. If you don't have the exact description of a document that you're looking for, you're unlikely to get it, and if you can't give a good reason for wanting or needing that document, then you're not going to get it. So discovery is really something that litigation attorneys do not worry about very much in Latin America. Basically, if you don't have the documents, it's going to be very difficult to get them. So basically, the attorneys in Mexico and Latin America generally, attorneys' offices are fairly safe places to keep documentation. There are some countries that are beginning to chip away at those rights, but generally in Mexico and many of the other jurisdictions, law firms are still fairly safe places to keep the information. But if the authorities go to the client's offices, then asserting the privilege is not really going to be a limitation on the documentation and information that they will be able to obtain. Now, this attorney-client confidentiality obligation is not limited to the litigation context, so that's not really an issue. And then we also talk about whether it extends to in-house counsel, and theoretically it does, but there are arguments that if the attorney is an employee and is an in-house counsel, then the attorney might be treated as an employee rather as a lawyer in that context. But the information would be available to the authorities from other sources, even if the lawyer is protected in the company context. And then another point that's important is that this duty and right of the attorney to maintain documents in confidence only applies to attorneys admitted in the jurisdiction. So if the person is an attorney, for example, traveling in the country, this right and duty of confidentiality is not going to apply to that attorney. So it's important to keep those matters in mind as you think about the information that's in the jurisdictions of Latin America, and the people who have custody of those documents and that information.
Great, thanks, Jonathan. Well,
I was just going to add something. This concept of learning whether the attorney-client privilege extends to in-house counsel, and learning whether in the jurisdiction where you are going to be acting as a counsel, for example, you are in-house counsel based in the U.S., but you're going to a Latin America jurisdiction. When you get there, you do not enjoy, and your communications do not enjoy attorney-client privilege locally if you're not locally barred. And sometimes in the U.S. litigation that may issue with respect to this cross-border issue that you're dealing with, the U.S. courts will apply the attorney-client privilege rule of the foreign jurisdiction and will not give protection to the U.S. attorney who went down to South America to conduct the investigation or to assist with some regulatory issue that was going on in Latin America.
so why don't we move on to just a discussion on the DOJ and the SEC policy on privilege waiver. And before we get into that, I just wanted to take a few minutes to talk about the concept of selective waiver, because that's sort of what underlies the whole discussion today. And the idea of selective waiver is that that you can, or the concept is that a disclosure of a privileged document to a third party does not cause waiver as to that document to all parties. And look, the general view in the U.S. is that selective waiver is not available. So if you produce a document to a privileged document to a third party, that document generally loses its privileged status, and you can no longer credibly withhold that document in discovery or otherwise from other third parties who have a reasonable basis for requesting production of the document. Now, with respect to productions of privileged communications or privileged documents to the SEC and in some cases the DOJ, there's a question as to whether or not selective waiver is available in productions to those agencies. That's actually not an issue we're going to necessarily focus on today, but I just add that. But one large exception to the general sort of prohibition against selective waiver in the U.S. Is 12 U.S.C. 1828X, and we're gonna save a discussion of that until later in the presentation. But that is the sort of the shield that financial institutions have to protect themselves from being deemed to have waived privilege with respect to materials that they produce to regulators, and we'll get into that. We'll get into that in a bit. But the point that I really wanted to focus on here is that as a general matter, but for 12 U.S.C. 1828X, and some other nuances like certain productions to the SEC or the DOJ or other law enforcement authorities. As a general matter, selective waiver is not available. And Jonathan, did you want to just touch on Latin America just briefly?
Sure, and just to make the point that only clients can waive that duty of confidentiality. So the attorneys cannot be forced to turn over documents, and for that reason, it's very rare for law firms to be raided or anything like that, or even requested. We even have requests for documentation from authorities. So it would be very difficult for private parties to obtain that information or documentation from authorities, even through the local equivalent of a FOIA request or something along those lines.
Great, thanks. So let's turn to the next slide. And look, before we move on, just to reiterate, I think Danny covered this at the start, but if you have questions during the presentation, feel free to send them in. We have the ability to sort of see them as we go along, and we'll try to integrate the answers to those questions into the presentation. But now just a few minutes on the sort of contrast in the position that the SEC and the DOJ take with respect to production of privileged materials in the context of an investigation versus the position that bank examiners take in the context of their supervisory role of the financial institutions that they supervise. So look, the DOJ policy on privilege waiver is very clear, and it's that that the DOJ will not require the target of an investigation to waive privilege as to relevant communications that are otherwise protected. The SEC as well, the policy of the SEC as well is to not require investigation targets to waive the privilege. And the SEC's position has not always been, this has not always been the case. Now, in extraordinary circumstances, the SEC may ask an investigation target to waive the privilege, but it's rare and done in extraordinary circumstances. Now, but just we always sort of talk about cross-border issues. Contrast the DOJ position to the position of the SFO, and the SFO, on the other hand, has been clear that in order for an investigation target in the UK to receive cooperation credit, the SFO expects waiver of attorney-client privilege with respect to certain materials. So clearly a distinction between the U.S. law enforcement authorities and UK law enforcement authorities on that issue. One more point on the concept of privilege waiver. There has been some discussion, in particular, I'd say starting with the Yates memo, and certainly in connection with the FCPA corporate enforcement policy, as to whether or not, notwithstanding the stated policy position, whether cooperation under the corporate enforcement policy might perhaps require some waiver of privileged materials. I think the DOJ has been adamant that it does not, but where you're required to come in and explain the results of your investigation, and with very detailed presentations, binders of documents, you start to maybe shift into whether or not you're actually disclosing attorney work product. But that's sort of a separate issue. But as a general matter, the policy on privilege waiver is to not require financial institutions and other corporates to waive. Now, the federal bank regulators.
So before we move on, just 2 comments. Terry mentioned the Yates memo, and I believe most of our attendees are familiar with the concept of what it is. But basically, for some institutions in Latin America that may be participating in this, that's the memorandum where it was set out that whenever there is an investigation and some issues within the company, that they would look for the individuals responsible for the actions that are being looked into. Another comment that I would like to make is that despite the manual and the fact that the staff should not ask a party to waive attorney-client privilege, it does happen, and soft conversations, and sometimes it is requested softly, and it's important to know that how to respond to that, and it always depends on the situation and what is in the memo and what is being discussed. So now I'm passing on to Terry again.
Thanks, Danny. So as to the federal bank regulators, as many of you are probably already aware, your supervisors do claim authority to compel disclosure of privileged information during examinations, and in some cases there is pressure to share those materials with the examiners. We'll get into in a minute some of the specific positions of each of the regulators that you all may deal with. But Jonathan, did you want to provide maybe a slight contrast to the position in some of the Latin American jurisdictions?
Sure, and authorities have in the past been not been very active in requesting or demanding documentation from companies, and one of the reasons is that traditionally in Latin America we have not had any criminal liability for corporate entities. In recent years, there's been a significant increase in the number of countries. I'd say now most of the countries in the region have criminal liability for companies. So authorities are getting a lot more powers and becoming a lot more aggressive in obtaining documentation from companies, and they don't have any kind of, once that issue is on the table of obtaining documentation from companies, there's no limitation on that documentation. And as far as regulators sharing documents with other government institutions, certainly as these criminal liability statutes come into play, then we expect to see this issue arising a lot more frequently, and because privilege is not there as a defense, we think it's going to be a significant source of information and documentation for the criminal law enforcement authorities in our jurisdictions.
Great, thanks, Jonathan. So just to look at some of the individual positions, and I guess we'll start with the OCC, the Office of the Comptroller of the Currency, where you see a quote from the Chief Counsel up on the slide, which attorney-client and work product communications maintained anywhere in a bank's books and records fall properly within the scope of banking agency's examination authority and may be shared with the examining agency by the supervised institution. Clearly states the position of the OCC that privileged materials are subject to production to the OCC in the context of an OCC exam or otherwise. And a slightly stronger statement from the General Counsel of the Federal Reserve from a few years ago. Complete and unfettered access to an institution's most sensitive financial information, and that includes information that would otherwise be privileged. So you can see the position of the banking regulators juxtaposed to the idea that there is no selective waiver in the U.S. Could present an issue, but for the protections of 1828X, which we'll get into in a moment. Although we'll discuss whether the protections of 1828X are sufficient. So let's just quickly look at the CFPB and the FDIC, which is really just more of the same. And you'll see the quote from the final rule amending 12 CFR 1070 that was published in the Federal Register as to the CFPB. The Bureau continues to adhere to the position that it can compel privileged information pursuant to its supervisory authority. And then finally, we have a quote from the FDIC. So we've got the OCC, the Fed, the CFPB, and the FDIC all taking the position. Look, we will require the financial institutions who we supervise to provide to us otherwise privileged materials, privileged information, if we think we need to see those materials in the context of fulfilling our supervisory mandate.
So, Jonathan, do you want to comment on Latin America?
Sure. No, and again, because there's not this privilege of documentation in jurisdictions in Latin America based on the theory of that we have in the U.S. Any information sought by the bank regulators in Latin America will not have that limitation, so it will be broad.
Great, thanks. So just moving on to the protection that I've been discussing, and it sits at 12 U.S.C. 1828X, and it's up there on the screen. And essentially, what it does is it protects these productions, and it effectively says that you're not. The statute does not provide for selective waiver, but what it says is that producing the privileged materials to bank regulators does not constitute waiver. So in the context of producing to your supervisor or your examiner, you're not going to be deemed to have waived the privilege. Oops, sorry about that. And U.S. courts have upheld this concept. Two cases that we wanted to highlight, one in the Southern District of New York and one out in Oregon, that effectively supported the idea that a production of privileged materials to the banking authorities does not constitute a waiver. So what does this mean? Should we be comfortable that because we have this protection, we're not concerned about waiver? And as a starting point, does 1828X even require financial institutions to produce the materials? So as a starting point, while 1828X protects productions from being deemed a waiver, it does not necessarily compel the production of these materials. So there's a very good argument that the banking supervisors and the banking regulators in their supervisory capacity are overstepping their bounds, because in explaining their policy and their requirements, their positions are not based in statute. They're based on the idea that we need unfettered access to the financial institution's books and records in order to fulfill our supervisory mandate. And they often will point to 1828X for the proposition that banks are compelled to produce these materials to us. But actually, 1820X does not compel, it just protects the disclosure. Then the other limitation on 1828X is it does not address duties or the requirements of the regulators with respect to the disclosures. So it does not place limitations. It does not set ground rules as to who or where the materials that a financial institution shares with their supervisor. And look, we live in a regulatory environment where our regulators are sharing information, are collaborating on cases, collaborating on investigations. If I'm a financial institution and I'm producing highly sensitive, privileged materials to my supervisor, I'm going to have some concern that those materials could very well end up in the hands of another regulator, and even the hands of an enforcement body within that agency. The idea here is that we produce these materials to our supervisors. But these materials could very well end up in the hands of enforcement at the Fed or enforcement at CFPB, and now you may be dealing with an investigation where those enforcement bodies already have privileged materials that are relevant to the issue at hand. So it's not, the idea that there is no waiver is not necessarily it's not necessarily comfort. I gotta go. Hey, Jonathan, I think we're missing your slide on this point.
Okay. Well, I would just say here that if information or documentation is obtained circuitously from a regulator in one of the Latin America jurisdictions, and Terry, you can comment on this as well. But I think that we would still want to consider asserting the privilege because in the U.S. because it's the nature of the documents and not the means by which it was obtained. But generally, you want to make sure that you're not needlessly storing or even providing access to documentation in jurisdictions that don't have the privilege, because it may end up in the hands of regulators or agencies in Latin America, and then getting back to agencies and regulators in the U.S.
Yeah, I was at a conference earlier this week, and there were actually a panel of enforcement agencies as well as bank regulators, and throughout the panel, the sort of the thrust of the discussion was how the DOJ, the SEC, the CFPB, there's a representative from the Fed, how they really are now cooperating with each other in the course of investigating, in particular, financial institutions. And the point was made that this includes the sharing of documents that they may have in connection with a target or investigation. So the point is, just because your supervisor asks for the materials does not necessarily mean that you immediately want to provide them. And maybe we can move into some tips for protecting the privilege should you, should your supervisor require you to produce the documents. The first is seek a confidentiality agreement. Don't simply rely on that the protection 1828X. Put in writing that you are producing these materials to the bank supervisor. You're doing it because the supervisor has asked for the materials in the context of their supervisory role. You're going to want to, and put restrictions on with whom that supervisor can share the materials in that confidentiality agreement. Look, they may not agree to it. Maybe it is just in a letter that you send to them, but you should make clear to the supervisor or the examining authority that you are producing these materials to them only in their capacity as a supervisor, and your expectation is that these materials will not be shared with other agencies, or frankly even within the agency with enforcement staff or the like. Of course, mark the documents as privileged and confidential. Mark the documents to make clear that they've been submitted pursuant to the protections in 12 U.S.C. 1828X. Also, and we do this oftentimes in investigations with the SEC and the DOJ, where parties request information that you may in the future assert some privilege or some protection over, be it the attorney-client privilege, the attorney work product doctrine. Consider setting up a reading room where the agencies can come in and review the materials. We'll do that often in respect of enforcement cases where we're in a cooperation mode. We may have done a very robust internal investigation. We may have interview memos of those of interviews with employees or third parties or the like. And the SEC or the DOJ or the Fed will say, well, we want to see your interview memos. And because we do not want to run the risk of having then selectively waived the privilege with respect to those memos, we'll oftentimes set up some sort of a reading room. And by and large, and everything of course is circumstance dependent, but by and large, regulators can get comfortable with that arrangement. Of course, if you're in sort of a cooperative posture, from the start of the relationship.
Just some comments on the second tip. Mark your documents as privileged and confidential. Make sure before you do that it's actually really a privileged and confidential document. In other words, do not overuse this tip, because then you may end up with an issue where you are actually waiving the title that you're putting on a document because you're overusing it. And I also wanted to note that we have seen in the past few years several corruption cases arising from Latin America. They're involving companies, they're public traded companies in the U.S., and several of those cases are followed by securities class action. So just a note on the importance of this topic, on the importance of maintaining, always maintaining in mind the confidentiality of communications, the sensitivity of information that's being shared, so that you can prevent the class action litigants from getting more information than they should.
Great.
And as far as Latin America is concerned, even though we don't have this well-developed document of doctrine of privilege, there are certainly other ways that you should explore to protect documentation and information. Some of them will allow you to keep the authorities from getting the documentation altogether. That might be, for example, a right against self-incrimination. possibly also personal data protection. There are new laws in many of the jurisdictions in Latin America, including Mexico, on personal data protection. It's a law that's being actively enforced, and agencies are increasingly aware of the importance and the really the applicability of this personal data protection law in many different environments and many different contexts. We get probably on a weekly basis, a new publication in our equivalent of the Federal Register, Diario Oficial, that new regulations coming down on personal data protection. So it's a very active area of law. Trade secrets as well. Even though having something as a trade secret or some other sort of business confidential information may not keep it out of the hands of the regulators, it will at least protect it from, in most cases, from a Freedom of Information Act request. So we've seen with greater access to documentation. We've also seen the authority in charge of providing freedom of information also denying many requests for information when it involves trade secrets, business confidential information, personal data. There's each jurisdiction has its own categories that are being enforced strongly in the jurisdiction. So it's important to look at those alternatives to the privilege, and along the lines of one of the other points that Terry was mentioning, establishing a protocol within the company for accompanying government officials. This issue of going into companies and acquiring documentation is relatively new here in Mexico. Up till a few years ago, government officials, agencies were very deferential as far as obtaining documentation, and there's still some of that deference. And so if you have a protocol set up, you can certainly control a lot more of the environment, make sure that you know what documents are being produced, and stay to the extent possible, stay in charge of the situation, and make sure that counsel is present for any documentary review, locally admitted counsel, and then as I mentioned before, making sure that information and documentation that's not strictly necessary for the operation in any jurisdiction, that be kept, preferably in the U.S. Or in another jurisdiction where the privilege is available.
So, thanks, Jonathan. So I think we just have we're at our question point, but I think the point that I would leave folks with before we start to take questions is that producing privileged materials to your bank regulator should be a big deal, and it should not be something that banks sort of routinely do, simply because it's the position of the bank regulator that you're dealing with to require such production, and that you have this protection against having waived protections with respect to those materials under the statute that we've discussed. If the supervisor does ask you to produce the materials, you are well within your sort of purview to require them to explain to you why they need these particular materials in light of the risks that banks face when they do produce this type of documentation.
Thank you, Terry. So we're now at our questions period. We have a few minutes. If you have any questions, please type them in the question box in your GoToWebinar control panel. Oh, and we received some requests for the material for the slides. We will certainly email them to you after the presentation. We do have a question regarding privilege in Latin America. And the question is with respect to communications between U.S.-based counsel for a company with subsidiaries in Latin America and the Latin America subsidiary employees. What is the recommendation? Assuming that the Latam jurisdiction requires the attorney to have the bar of that local jurisdiction. The recommendation is, depending on the situation, you should engage local counsel to make sure that the communications are protected and have the local counsel present.
I will say, just a follow-up on that question. If the purpose of the communication with the employees in the Latin American subsidiary by the U.S.-based general counsel is for the provision of legal advice under U.S. law. So, for instance, maybe there's a question on compliance with the FCPA. Courts in the U.S. Will generally take the position that that communication is privileged under U.S. law to the extent that a third-party litigant requests production of the communication. So you do have some protection in that respect, at least under U.S. law.
And I think certainly with respect to U.S. counsel who's doing their work in the U.S. And for example, preparing maybe an interview summary of an interview held with an employee in a Latin America subsidiary. You know, certainly I think that U.S. counsel would be able to. I would probably counsel them to assert the U.S. privilege, because that's the jurisdiction where they are and where they're practicing. I think that the for example, the Mexican authority would have significant barriers and hurdles to try to get something from U.S. counsel who's actually physically in the U.S. With the documentation in the U.S.
Agreed. We do have a question with respect to the certificate of participation. FIBA will send a document for your signature so that those can be provided. And then we also have a question with respect to, under U.S. law, whether it would be necessary to execute an NDA with Latin America local firms to guarantee the attorney-client privilege.
So I think if the question is if the U.S. sort of, to go back to our last hypothetical, if the U.S. general counsel is engaging with a local law firm to assist that U.S. general counsel in providing advice to the U.S. parent on a question of U.S. law, the question is, do you need to execute some sort of a non-disclosure agreement with that local resource? It would not necessarily be a requirement, but it would certainly be a good idea, because that NDA then supports the argument that the communication is confidential, because you're requesting that local resource to not disclose the communications to any third party. So when you're making the argument for privilege, again, in a follow-on litigation or other proceeding, We talked about the 4 elements earlier. One of those is confidentiality of the communication. In that case, you would have a record, a document that reflects that your intent was for the communication to be maintained in confidence.
And certainly to the extent that you can use local counsel, that local counsel, to the extent that they have the documents and information in their possession instead of in the possession of the local branch or subsidiary, that's going to protect effectively that documentation information from regulators and agencies here in Mexico or in other jurisdictions in Latin America.
Thank you, Jonathan. I think we're through with our questions, so I would like to thank all the participants for attending and looking forward to the next webinar.
Thanks, everyone.